Hey guys, welcome to Maneuver Education. I'm Advocate Nisha Lotia, and my today's session is on the popular demand regarding the time management of a legal aptitude question. Students, as this is a universal truth that the entrance exam is time constrained, a serious aspirant is always under a dilemma that how much time is to be allotted to legal aptitude question. Do watch this video till end and please hit the like button as it will inspire and motivate me to make similar videos. And I promise that this video will solve all your problems related to time management and will provide you some additional information and tips for the same. But before getting started, let me tell you about the live class what Maneuver is offering about the ebooks. Okay, we have live class, we have ebooks, guys. We have shortcut techniques, which is very much crucial and important. As I told you, the exam is time constrained. We have the doubt class, which will solve all your questions which you face after hearing a mentor and when you give your own personal efforts to the questions. We have the recorded videos. If you miss any of the lectures, you can go through the recorded videos. We have topic wise test, and we have the mock test, which is very important, without which you cannot attempt a paper. And we have a WhatsApp group which will keep you affiliated with the same calibered people, and which can be keep you even motivated, guys. We have 10,000 plus questions, as itna practice to banta hai before your entrance exams, guys. And icing on the cake is that the mentorship at Maneuver are the faculties who appear paper every year, okay, who appear paper every year. So you have a mentorship of a right kind of a mentor required for the law entrance exam, guys. So don't what are you waiting for? Call up on 8828581454, or you can visit us at maneuveredu.com law entrance. And guys, I have them mentioned the link of the Google form, okay, in the description. You need to just fill up this form and send it to us, and our admin will get back to you. Okay, the team will get back to you. Now, coming back to the time management strategy, what I wanted to tell you that a serious law aspirant is always in a dilemma type. What is a correct time required for a legal aptitude question? Okay, so the correct time over here is nothing but anything that should be between 60 to 70 seconds. Okay, but how? The principle is so lengthy, correct? Even you have to read the facts, okay, and then again the four options, correct? So how can all be this done in 60 to 70 seconds, and yet you get a correct answer, the accurate answer? This can be done very easily. Just follow these tips and sure you're ready to go. Let's look at the first tip is read loudly. What happens is by reading loudly, there's 100% of concentration. Okay, there's 100% of concentration, and the understanding of the subject matter is parallel to this. Okay, so you don't need to reread anything. Okay, when you're reading loudly, I'm not asking you to yell or to shout in the examination center. No, I'm just asking you to open your mouth wide and read properly. For example, if the word is deceived, okay, देन आपको डिसीव्ड तो ईडी जो लास्ट में आता है तो वो ड का भी साउंड आपको खुद को आना चाहिए. दैट इज कॉल्ड द एग्जैक्ट रीडिंग. इफ आई एम सेइंग द वर्ड इंटिमिडेटिंग, so the entire word intimidating, you should read it carefully. अगर इंग है तो आपको वो ग का साउंड भी आपको खुद को आना चाहिए. And you have to read it wide, your mouth open. So what will happen? You are not lost anywhere while you're reading. Secondly, you are understanding what you're reading. Okay, I just don't want to कि आप नजर घुमाओ. I don't want that attitude at all. मेरे को कोई भी laziness नहीं चाहिए examination center में. I want you to read loudly, okay, and make it a habit from today onwards that whatever you're reading loudly, okay. Now, never reread the definition. What do I mean to say by this? That what is a principle basically? If you tell me, ma'am, explain me what does it mean when they write the principle is mentioned. They give you a definition. Okay, if I say the question is based on proposal from a contract act, so in the first 3 lines of the principle there will be the definition. Now this definition वो सालों से वैसा ही है. It never changes. This is a definition of it, correct? Your main question is what it is, of course, based on proposal, but it will be based on a condition which is mentioned after your definition. So you never, whenever if you don't understand principle, okay, I get that you don't understand the principle in the examination. ये हो सकता है, possible है, correct? लेकिन when you're reading loudly and understanding the subject matter, तो principle नहीं समझने का chance बहुत rare हो जाता है. Okay, but in case if you don't understand the principle, guys, you're never rereading the definition, because this is a legal language which is very difficult for you to understand at the entrance level. Okay, so आपको मेन कॉन्सेंट्रेट क्या करना है, आपको कंडीशन पे कॉन्सेंट्रेट करना है, आपको प्रपोजल पता है, व्हाट इज अ प्रपोजल, व्हेन यू ऑफरिंग समथिंग दैट इज अ प्रपोजल. ओके, सो उसकी डेफिनेशन को कभी रीरीड नहीं करना, गाइस. एंड द कंडीशन, whether it is relating to the number of the parties, or whether it is relating to communication, all those things are called the conditions, the essential elements of proposal. You have to pay attention on this. Okay, and then read the facts. I want your reading the facts also to be loudly, and then your MCQs. Now, not rereading the definition will at least save your 20 seconds, guys. Because when you're rereading the definition with the thing that आपको नहीं आ रहा है, तो आपका confidence थोड़ा low हो गया, आपका confidence थोड़ा low हो गया यहाँ पे. Okay, so refrain, restrict yourself from rereading the definition. Definition change नहीं होना, अगर proposal का है तो वो proposal ही है. I'll be solving one question after this slide, and I'll explain you again what I mean to say by that. Okay, use the process of elimination. Now you know कि ये proposal के बारे में है. If the principal is telling about the proposal, then the acceptance is never going to be your answer. Correct, the agreement will never be your answer. Correct, whether that proposal is correct or not will be your good choice. Okay, so you have to pay attention to all these things. Your answer language has to be as per the principal's language. Okay, so use the process of elimination. Correct, next is answer must contain legal aspect. Very, very important is this. Any answer which has a social angle to it. Okay, any answer that has a religious angle to it, any answer that has an illegal angle to it, correct, this can never be your answer, guys. Your answer should always and always contain a legal aspect. Okay, mostly 90% of the cases में it should contain the language of the principle, guys. जो principle की language होगी ना, वही आपके answer की language होती है. Correct. Next is refrain to choose mark for review. Now, what is this mark for review, guys? Understand one thing. If you have 30 questions in your examinations, okay, आपने 30 में से 20 क्वेश्चंस को मार्क फॉर रिव्यू चूज किया है, सो फाइनली ये मार्क फॉर रिव्यू आपके एग्जाम में एक्सेप्ट तो हो जाएगा. बट इफ एट ऑल, इफ यू हैव एनी टाइम एंड यू वांट टू एक्चुअली रिव्यू आपका आंसर, so among that 20, you think you have time to review all those 20 questions? Never. So in case if you have only marked 2 to 3 options for mark for review, then you can actually go and work out. So don't just thinking I'll come back to this question and again put some efforts. उससे अच्छा वहीं पे आप 5-10 seconds ज़्यादा दे दो and finish it off. Refrain yourself from going to the options of mark for review. Okay, students always think I'll come back. लेकिन जब अगर आपके पास real में time बच रहा है and you want to really go through it, लेकिन कितने आपको लग रहा है 25 questions you can review? No, that cannot be practically possible. Okay, so 2 से 3 questions है in each section, so that can be reviewed. Okay, so for the entire paper, don't be that frequent in choosing mark for review. Okay, the next thing is 60 seconds is an ideal time for the legal aptitude question. Yes, guys, 60 seconds is a correct and ideal time. There are some questions which are too tiny and too small, guys, like the length में जो small है वो आप 45 to 50 seconds में भी कर सकते हो. Okay, applying these techniques, reading loudly, never reread the definition, and choose the elimination process. Okay, so practically I'm going to show you some questions, and this will help you to boost your strategy, guys. The principle says negligence is a breach of duty or a failure of one party to exercise the standard of care required by law, resulting in damage to the party to whom the duty is owed. Now this is my definition. Okay, this is my definition, because this definition is telling me that the facts and the options can be something about the negligence. Okay, about the negligence. Correct. So this is the definition, and in any case, I'm not going to reread this definition. Okay, let's see what is it. What the question tells us ahead. A plaintiff can take civil action against the respondent if then respondent's negligence causes plaintiff injury or harm. Okay, so this is a normal type of a question. It is like negligence of breach of duty जो आपके torts को लेके होता है. Correct. He went to a cafe and ordered and paid for a tin of soft drink. Now over here, if I'm reading loudly and understanding, I never need to reread this, guys. Okay, वो D एक person होगा, वो cafe गया है अपने लिए खुद के लिए एक tin of soft drink order किया है. The tin was opaque and therefore the contents could not be seen from outside. Okay, so tin transparent नहीं था, वो opaque था, तो उसमें से आपको अंदर क्या चीज़ है वो you couldn't see it, correct? She, that is tea, consumed some of the contents and then lifted the tin to pour the remainder of the content into a tumbler. See, however fast I'm reading, guys, I'm very clear in my reading. अगर र का sound है तो र का sound मेरे को खुद को आ रहा है. So this is the kind of reading I want. You know, I don't want that passive. I don't want that lazy reading. I want that active reading. That energy has to be there. Correct? The remains of a snail in decomposed state dropped out of the tin into the tumbler. Now वहाँ पे कोई कोई कचरा होगा, like it was a decomposed of a snail, correct? Dean later complained of a stomach pain and her doctor diagnosed her as having gastroenteritis and being in a state of a severe shock. Now if you don't know the meaning of this, it means कि उसको कुछ disease हो गया, okay? And it is that it can be a thing because उसने ऐसा juice पी लिया होगा, correct? She sued the manufacturer of the drink for negligence. So we all know, guys, we all know that this can be, your thoughts, correct? Applying the aforesaid principle, okay, which of the following derivations is correct as regards reliability of the manufacturer in the given situation? Now this is your main question. The manufacturer is liable for negligence as its own duty to consumers to take reasonable care to ensure that its products are safe for consumption. The manufacturer is not liable for negligence as there is no direct contract between D and manufacturer, no duty is owed. Now we know that contract to ho hi nahi sakta because we are already talking about torts, so this will never be my answer, guys. Correct? The manufacturer is not liable for negligence as it would otherwise become very difficult for the manufacturers to do business. Now this is a social aspect, which I said is not having any legal aspect, so this also cannot be my correct answer choice. The manufacturer could be liable under criminal law but not for the tort of negligence. Now we are talking about torts over here, so criminal law. So this is something that is not mentioned in my principle, so this will also not be my answer because tort of negligence ही है because it is talking about a negligence, correct? And it is talking about a civil action. So मेरे को एक criminal तो मेरे को चाहिए ही नहीं. I'm left with only one option, and this looks even reasonably good to me. That of course the manufacturer has to be liable, correct? He owes a duty towards whatever his products are. Did you understand? So please refrain yourself from rereading. When you're reading at once, at that very minute, you have to try and understand. देखो ये entrance level it is not the LLM exams, correct? So they cannot ask you very much, highly twisted questions. It will be a direct application of the principle. In this question, I can say that it is a direct application of the principle. Let's solve 5 more questions, guys. Okay, what is the principle saying? Culpable homicide is murder if the act by which the death is caused is done with the intention of causing death, or if it is done with the intention of causing such heavily bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused, or if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, or if the person committing the act knows it so imminently dangerous that it must in all probabilities cause death, or such bodily injury is likely to cause death, and commits such an act without an excuse for incurring the risk of causing death or such injury as aforesaid. Now we all know that this is just the definition, correct? You don't need to reproduce this definition, तो आपको सब कुछ समझने की जरूरत नहीं है. It is all, if you know the concept that culpable homicide is murder, this much is enough. But when it is murder, okay, when it is such a bodily heavily injury, correct? Now what is the second condition over here? So in this case, you're never rereading the definition, okay? Now over here, when a criminal act is done by several persons in furtherance of a common intention of all, each of such persons, so there has to be a common intention, correct? Each of such person is liable for the act in the same manner as it were done by him alone. Now this type of question I can take your 70 to 75 seconds because this is the lengthiest. अगर कोई डेफिनेशन है आपके लीगल में तो वो सबसे ज़्यादा इंपॉर्टेंट होता है कल्पेबल होमिसाइड अमाउंटिंग टू मर्डर एंड नॉट अमाउंटिंग टू मर्डर. ये जब आता है ना, स्टूडेंट्स नॉर्मली टेक फ्रॉम 70 to 75 seconds, okay? But do justice with this question because this type of questions जो ना आपको कॉम्प्लिकेटेड लगते हैं उसके फैक्ट्स बहुत ही इजी पूछते हैं because I told it is just an entrance exam, okay? Why a small boy was guarding the field. Now the two definitions over here, I would like to explain you this first. That the two definitions, that is your culpable homicide amounting to murder, and there has to be a common intention. There are two ingredients of this principle. So you have to keep these things in mind, guys. Okay. Why a small boy was guarding the field Z and M outsiders trespassed and started harvesting on protest by Y. Correct? A small boy he is, okay. They beat him up and hearing his cries, X and P, uncles of Y, who were working in different directions, rushed in. Now they are working in different directions. तो हम लोग के बीच में कुछ भी बात नहीं हुई है. Just because of his cries, of the child's cry, X and P with the uncles, and so they are coming to, for their head, for the boy's head. One of them, that is X, fired at the trespassers, killing one of them and ran away. P was arrested and charged. Okay, which of the following statements is correct? Now यहाँ पे who fired, X fired, and who is वो तो fire करके निकल गया, but who is charged? P is charged. Now let's see. He is liable for murder because of the similar intention of both of the brothers. Was there a similar intention at the first place? Correct. He is liable for murder because of the same intention of both the brothers. Same and similar, only two difference. Correct. He is liable for murder because he was present when his brother fired at the trespasser. He is not liable because there was no common intention to kill. Now over here, guys, when you see the options A, B, and C, this is not having the legal principle. This is not having the legal principle because why, guys? There is no common intention. They were both coming from a different direction. दोनों ने मिलके कुछ murder plan नहीं किया था. Correct. So why is, can P be held liable for murder? P cannot be held liable for murder. Correct. So here X has fired the gun. Okay, तो जो भी होना है वो X के साथ होना है. P cannot be held liable for his deed because there was no common intention at all. Correct. So when you see A, B, and C, okay, A, B, and C over here does not have my principal's language. Only D is having my principal language. D is my correct answer choice over here. So this is the way, guys. Never reread the definition. First time आप read कर रहे हो, try and give your 100% to the question. Do justice with the question, and I am sure you will ace through this section. Okay, there are more than 20%, 50 to 60% in your legal aptitude section, which will be very, very easy, very, very, the length will be also quite small, which can be just be done, within 50 to 55 seconds, okay? And rest couple of questions like, yeah, I said culpable homicide amounting to murder. These types of questions can take you 70 to 75 seconds, but it's okay because they will give you the highest accuracy. Legal section can give you highest accuracy students, okay? Now, guys, once again, I would like to tell you we have, the live lectures, we have the classroom lectures, we have the books, we have the mock test, we have the entire package required for your, complete, preparations. And you can join us, subscribe our YouTube channel. You can join us our Facebook. We have Instagrams, okay. And on Telegram channel, we keep on posting the quiz, the vocabulary questions, and those things that will help you in your strategy. And for the link of the Google form, guys, I have mentioned in the description. You just need to fill up the form and our team will get back to you as soon as possible. Okay, so prepare yourself to the best level, and I'm sure this video will be extremely helpful to you. Stay safe and thank you.